Hi, everyone. I'm Denise O'Malley. I'm the founder of You Define Wellness and the host of the different meetup groups out there called the Wellness Experience and Healthy Living Practitioners. And we are bringing to you really our first Practice Management 101 tips, webinar, guide, helpful information to help you in your health and wellness practice. And, I put it out there to the world and said, what is it that you want to hear about for your practice? And the very first response I received was, I need help with independent contractor agreements. And so I went out to Facebook land and I asked for recommendations for people to tell me who they felt would be an expert that we could bring in to share with you a great deal of information. And Victoria.Edwards' name came to the top of the list. So it is my pleasure to introduce to all of you Victoria.Edwards, an attorney in the Colorado office of Jackson Kelly. Victoria, thank you so much for doing this today.
Of course. Thanks for having me. So I want to make this almost like a question and answer type of thing. I'll go through what I think are the major points that someone looking to engage an individual in an IC agreement, independent contractor agreement, needs to think about so that their individual is not classified as an employee, which comes with a lot of issues. I apologize. My email file. And so just things to think about in drafting your contract. So we'll get right to it. My first slide, why should you care about misclassification? Well, if you have unpaid taxes out there, that could be an issue that your company could eventually have to deal with down the line if that independent contractor isn't paying their taxes. Fines at a federal and state level, investigation, prosecution, debarment in the worst case scenario that prevents you from entering into contracts for your businesses or otherwise doing what you need to do to engage in your business. So it's pretty important stuff to get right from the get-go.
Okay, I'm going to interrupt you because this is just my nature, just letting you know. When I hear something that really piques my interest, I've got to jump in. So I've heard about some of these other things that, classifying the people who are working with you, I know is so really important, but I had not heard that you could be prevented from entering into contracts for your business if you have done that. Seriously?
Yes. And it depends what type of business you have, especially if you're doing work for the government. That could be a huge issue for you, right? Because you're relying on contracts. So yeah, it's one of the worst case scenarios, but it is a possibility.
Wow. Oh, wow. Okay. Yeah. Carry on.
Yeah. So independent contractor versus employee. It doesn't matter what kind of independent contractor you're dealing with. It could be a lawyer, accountant, or a plumber, or drywall hanger. The issue with any type of individual that you're hiring as an independent contractor is what kind of control do you have over that individual? And there's three areas where they can consider the control factor. Behavioral, what you're having them do and not do on the job. Financial, how you pay them, what perks or benefits you're offering, if any, and then the relationship with the parties. Okay, so we'll go through each of those subcategories, and then we open up the questions. So the first one, behavioral control. Who has the right to control the way the work is done? Okay, so let me give you an example. If you put together a very stringent bullet point list of what they're not to do and what they're to do on the job, and that's in their contract, that could be looked at as an employee type of situation. The nature of independent contractors is that they're coming in with a level of expertise that doesn't require much management and doesn't require training, right? You're bringing them in, they know what they're doing, and you have to let them do what they're supposed to do, right? And obviously the important part is vetting that person, knowing that they're an expert in what they're being hired to do. But you have to keep that in mind when you're bringing them in as an independent contractor. I mean, you cannot control the way that they're doing their work as a general matter. They're supposed to come in as the expert and know what they're supposed to do for you. It doesn't matter if you actually exert the control or not. What matters is what does the contract say, because that's the main item that connects you to your independent contractor and that dictates what kind of relationship you have. So if you're making a huge list, controlling what they do and don't do, what they're supposed to do, what time, and where they're supposed to be, any entity at the federal or state level is going to look at that and say, you're exerting some control there. That's not just. So that's one important thing to keep in mind when you're drafting your contract. So kind of diving into the area a little bit more. The type of instructions, what I was talking about before, when and where to work, what tools, what equipment you're supposed to use, where to buy them, who you hire, can you bring in workers, who must do certain tasks, what's the order and sequence. If you are defining those in any great detail in your contracts, that can be considered, someone that's working under those confines can be considered an employee. So keep that in mind. The more instructions you give them suggests greater control. And that's just what it's about, the control factor. Another area, do they have to get prior approval? If so, they may be considered an employee. Are there instructions or rules that mandate what they're supposed to do? If they're a normal, building, for example, general contractor, if there are building codes they're supposed to adhere to, that's one thing. But if you're adding on more rules in addition to what they're supposed to do by law anyway, that can be considered a greater degree of control, and they can be considered employees.
So let me ask you this clarification. When you're saying prior approval, I mean prior approval to making any decisions for doing their job?
Yes.
Okay.
Right. Exactly. So like I said before, if they're an independent contractor, they should know how to make these certain decisions based on, their expertise coming in. That shouldn't be something, if they are an independent contractor, truly something you should be controlling. Suggestions versus instructions. So you might have kind of a way of doing things at the office, or a practice, so to speak, that you would share with the independent contractor. That's one thing. That's a suggestion versus this is the way you have to do it. So that's a fine distinction, but something to remember when you're drafting these contracts. You can make suggestions, but it can't be an instruction. Wearing uniforms or logos, that's usually a sign of employee status. And that goes for all areas, professionals, non-professionals. Another thing they look at, your evaluation system as a company. So an independent contractor, they'll usually be, their performance is usually measured by what the work product is after a certain defined period of time. So the independent contractor agreement will say, you're to work for our company from November 2019 to December 2019. And this is the product that we're expecting. Okay. That's going to be a different contract than an employee contract, which is typically, their graded employees are looked at based on performance, on how they achieved their work efficiently or, under budget. Those types of performance markers are going to be considered employee status. Training, another area. Like I said before, contractors, you're bringing them in, they should already know what to do. That's why you're hiring them. And it's versus an employee. If you have to train someone you're bringing in, and it's intensive training, that's definitely going to be considered an employee status individual you're bringing in. So something to think about too. Okay, the second category, financial control. So significant investment. The marker is the more you're investing in tools or insurance or perks on an individual, the more likely they're going to be considered an employee versus an independent contractor. An independent contractor will come in typically with their own tools, equipment, and with their own insurance. And that's something that should be expressly stated in the independent contractor agreement. Same thing with expenses. Employees typically reimbursed. Contractors, that's something that they usually incur on their own. So contractors usually don't get reimbursed for expenses. If you have a provision in there in the contract that suggests they do, that could be a marker for employee status as well. This is a big one, freedom to contract with others. If they're an independent contractor, you cannot prevent them from working for other companies. If they choose to work only for you, that's their decision. That's a different fact pattern. But you cannot, in that contract, say you can only work for my company. That's a big marker. Method of payment. So contractors usually get paid a flat fee, or there's some type of schedule within the time frame that they're supposed to complete the project or the assignment, as opposed to employees that get paid weekly, daily, monthly, depending on your company's model. But that's also a big marker that they'll look for when determining whether or not they're an employee or an independent contractor.
Okay, so can I ask a question going back to that freedom to contract with others?
Yeah.
So what about non-competes? Or if you're afraid of having your intellectual capital being used someplace else and taking it, if you're putting any restrictions in to not be competing for the same clients doing the same work, is that getting into really gray area?
Yes and no. I mean, also it's very state specific, and I can only speak to Colorado. Okay. But generally, non-competes, even with an employee, are not favored in most states. Yeah. California hates it, and then Colorado's right up there with California. But yeah, they're not typically enforceable unless you're selling your business to that person. They're coming on to work. Mm-hmm. You know, that's like an exception to the rule, but generally speaking, they're not enforceable. Now, that being said, you can craft provisions for your contract that protect your intellectual property without turning that contract into an employee contract. Mm-hmm. So you can protect your data. There's a way to do that, but in terms of non-compete, it's pretty hard because most states want to encourage people earning a living. So it's kind of a policy thing. So it's hard to try to put those provisions in there, especially with an independent contractor agreement. Non-solicits, their courts, or at least Colorado, is more apt to try to enforce one of those. Mm-hmm. You know, taking employees if you leave and start your own business. Yeah. That one's a little bit more, they can swallow that one more, but the non-competes are usually not enforceable when it comes to these contracts.
The reason I asked it is one of the things that I have seen in the massage industry here in Colorado is one contract that it was an independent contractor agreement, but they had in the contract that you cannot do similar work within 1 mile of that particular practice, whether for yourself or others.
Was there a time restriction put on it?
That was during active status of the independent contractor agreement.
Oh, interesting. Mm-hmm. That's interesting.
Not to say it was legal. I'm just saying that it was.
Yeah, that's interesting. It's usually a situation where you're worried about them leaving and doing that. I mean, I would probably err on the side of caution and think that's probably not enforceable.
Right.
You could put anything in your contracts, is whether or not you could enforce it against the other party.
That was our perception as well, and that it couldn't really be, if you were an independent contractor, you couldn't tell me I can't make a living.
Right, exactly. Mm-hmm. So, I'd agree with that. Okay, let's see. Next one, ability to realize a profit. This is considered one of the strongest bases for determining employee status over independent contractor status. So what you have to ask yourself, does the worker have the ability to make decisions which affect the worker's profit or loss? If so, employee. So basically, the more involved this individual is in raising your company's bottom line, the more likely they're going to be considered an employee if this individual leaves and tries to sue you for back wages. I mean, that's the bottom line. Mm-hmm. I mean, if you're hiring them as an independent contractor, they shouldn't be that integral to your bottom line or making major decisions. It's just not what their role is to be. If you're going to have someone like that, that's so important, making decisions at a management level, especially. that person should be brought on as an employee, not an independent contractor. Okay, the third category, relationship of the parties. So like I said before, the written contract is what dictates your relationship with that individual. I mean, at the federal level, state level, they're going to look at the contract language to determine that. So one of the look at is how also how the person is paid. So typically in an independent contractor situation, you're not paying the individual. You're paying them through a company, an LLC that they've formed solely for purposes of taking the paycheck from your company. That's not an end-all, be-all factor, but they do look at that. How is that individual being paid? I mean, it could be a scheme or a way to tax dodge. You know, if they had to consider that, they would. But it's not a huge factor. As long as that person has company set up to receive payments, or you're paying the company, you should meet the IC status. Another big thing is this person receiving employee benefits, vacation, sick leave, health insurance, life or disability, tax qualified retirement plans, cafeteria plans. If they're receiving any of these under their contract with your company, they're going to be considered an employee, or it's going to be pretty likely that they will. Limits on ability to end the relationship. This is kind of tricky, and I've seen lots of IC agreements that mess this up. So you think terminated at will, that's independent contractor status, right? No. An employee can be terminated at will, typically an average employee. An independent contractor, there has to be a basis within the contract to fire that person. So if there's certain things they were supposed to do for the job and they haven't been meeting those obligations, that would be a basis to fire them. You write them up. You'd have a procedure put in place in your contract as to how to do that. But it's usually for cause is what I would call it. It's not the biggest factor to consider, but it's easy enough to fix in a contract, in your agreement. So you might as well make sure you're not having that person terminated at will. Have a basis, have a procedure, writing them up, receiving a letter, whatever it is. But there should be a basis in that contract for firing them. Okay, regular business activity. Is work provided part of the key aspect of business? So this is what goes back to what I was saying before. The more integral they are to the running of your business and the success of your business, the more likely they're going to be considered an employee. That's a huge thing for this analysis. Also, duration of the relationship. I touched on this briefly before, but an independent contractor is usually hired for a set period of time at a set rate. Project specific, what we like to call it. If you're dealing with a permanent or indefinite hiring period or a long-term relationship, that's going to lean toward employee status. So if you want this person to be an independent contractor, make sure you specify the time frame within which they're working and the payment structure set, not a monthly or weekly, but this is how much you're getting paid to finish this project. And if you intend to have them on for more than 1 year or 3 years or longer than what you would think a small project would take, that's fine. You can always renew the contract, but have it set at a certain time frame. And then if you can even detail that in your contract if it's going to continue on, but make it a set time frame versus just indefinitely.
So I got to jump in on this one too. Yeah. I call myself a reformed insurance agent, and in the insurance world, you contract with a carrier to represent their products. You're not an employee of them. You can have contracts with multiple companies. And so for the sales side, my experience has been that there are all these independent contractor agreements without a term on it. So they are indefinite unless there's reason to cancel it for cause. How does that fit into this?
That's interesting. I'm assuming this is the insurance world.
Typically, yes.
Yeah, so I know I litigate often in that area. And I know insurance is kind of its own beast itself. So if that's the practice in the industry,
It is.
Then I think it would be accepted and wouldn't be fought. I don't know if that goes for most other industries, but I mean, if it worked, I mean, every industry might have its own little thing that works in terms of provisions such as that. And that would be considered in the analysis, right? If an employee,
right.
Yeah.
So let's think of it as a healing practice. Let's say they do massage therapy and they have people who rent rooms. They're technically an independent contractor because they're under the umbrella of that particular massage practice. And they also may go out and do massage on their own with other practices as well. And they are under independent contractor agreements. It's not uncommon in our industry. So technically, in that kind of a situation, they should have a term on it and that it renews every year.
Yes.
Okay.
Yes. Unless, unless otherwise, set forth in the agreement if there's a breach of another provision in the agreement.
Okay.
Okay. So in conclusion, these are all factors that are considered. No one factor is dispositive, and depending on the fact pattern and maybe even the industry, as you've suggested, Denise, that's going to determine where the scale tips.
Mm-hmm.
So just briefly, there are safe harbors that could apply. There's analyses that are done for that to see if you fall outside, a breach of these rules. And just to note, the safe harbor does not apply to engineers, designers, drafters, computer programmers, specialty areas.
Can you explain what this means?
Yeah, so even if they went through all the factors that I just talked about, and that they found that there might be an employee status where you claimed as a company independent contractor status, there are safe harbors that would prevent you from being fined, right? If you had a quote unquote reasonable basis for the misclassification, you had an in-house counsel or, for big companies, you relied on an IRS determination or court ruling, prior IRS audit, someone came in and said you could do it this way, and then that changed. And then the last one, long-standing recognized practice of industry, like the insurance industry. Mm. So if there are certain items that you can point to, you might be safe from a fine from the IRS or other penalties. That's all I'm saying.
Okay.
And so there are task forces and statutes in these states really focusing on preventing this misclassification and deterring it. I could tell you in Colorado, in May, they passed a law making wage theft a felony. It's called the Human Right to Work with Dignity Act. So it reclassifies intentional non-payment of more than $2,000 in wages a felony theft. So they're taking these types of measures and to prevent this type of thing going on. The theory is interesting to me. I mean, they're basically saying you're stealing your employees' wages by non-payment or underpayment or misclassification of employees and independent contractors. So
an employer can be looking at a felony if they are misclassifying independent contractors.
Yeah, if it's over 2,000, I mean, in Colorado at least, you can be looking at a felony. So it's pretty serious stuff. Because I'm in Colorado, I just thought I put this slide in here, which is talking about the misclassification of employees as independent contractors act. In Colorado, as I think in lots of other states, the statutory presumption is that they're an employee. And it's your job, if you get hit with a complaint from the Labor Department, it's your job to prove that they weren't an employee. And once you do that, then the burden shifts, and then they have to prove they were an employee. So yeah, it's not something to fool around with. Something to take very seriously. You can see the fines.
Yeah.
Be pretty high. So
that could put a lot of small businesses out of business.
Absolutely.
That are misclassifying it.
Absolutely.
Wow. Okay.
The federal consequences and penalties, back pay, taxes, penalties for withholding. It can be very expensive. So it's not something to mess around with. So I won't go through all of this. I want to leave some time to answer some questions, but there's also state consequences, fines, debarment, other penalties. I just mentioned Colorado, you can be fined for a felony for doing that. And there's also other ways to get sued. there's no absence of ways to get sued, especially in these matters in the employment realm. So
yeah. So we do have a question. Michaela asked it, and she says, so if part of my job is to represent Bodybuilders Inc. at a business network, then that kind of sounds like an employee type position. Michaela, do you want to unmute and maybe clarify it a little bit more?
Sure. I just got approached for an opportunity to rent the massage room at a gym so that they could open up their offerings. And I'm kind of going down the self-employment route, so I think he was trying to offer to me that I could be a contractor. But to me, it kind of sounds like I'm stepping into employment.
You'd be representing the company.
Yeah, at the business networks that they're connected to. Yeah.
Yeah.
And as when I'm working there, I would probably be, on their website as their massage therapist.
Yeah, that definitely does sound more in the employee realm. I obviously have to know other things, and look at a contract, to really determine that. But if they're putting you out there as a face of the company, that would lend itself to classifying you as an employee. So maybe that'd be something, I don't know if you're friends with this person or what your intentions are of going forward with being with this company, but that might be something to talk with them about. And maybe it's just as easy as saying, hey, can we consider, since you want me to be the face of the company, can we consider more of a W-2 situation versus independent contractor, if that's the way you want to go. But yeah, I would tend to agree with you on that.
Okay, that's good to know.
Yeah,
it's a good question. Really good question. Okay.
So I just have just a few other slides here, best practices and what you can do to prevent liability in this arena. So best practices, keep your employee tasks separate from your independent contractor tasks. They shouldn't be doing the same thing. Make it easy for yourself. If it means having a separate procedure for independent contractors when you're hiring them and firing them versus your employees, do that. But have a process in place that treats them differently. And again, written contracts, that is the key. Your written contract should be pretty clear on these certain provisions that I discussed earlier. And the independent contractor should be on notice of their position. They should be on board and have an understanding after executing that contract with your company that what their role is. There should be no confusion, and that should be pretty clear in the contract.
Mm-hmm.
So I think that was it. I thought I had another one. So that is it. I am happy to answer any more questions. if you want to shoot me emails about a question on a provision that you want to add, or something you want to make sure is clear in your contracts, I'm happy to help with that as well.
We do have another question that is here, and it says, I may be collaborating with an established consultant, so we are exploring various options for structuring that. One thought was that I would work under the umbrella of her business, where she may give me referrals for a cut of the fees. She would invoice the customer, but I would be doing all the work independently and be responsible for my own expenses. Another thought was that I could be under her insurance. Is insurance a breaking point?
Yeah, if you're typically offering insurance to an individual, that's employee status. I mean, my review of these types of issues and what I've seen, that's an important factor. And also the way that you're structuring the payment as well. That could be an issue. I'd have to see the details of it, but if you're creating profit for the company, and how much that is, I'm not sure, but that could be a factor that's considered employee versus independent contractor.
And from the insurance perspective, most insurance companies, when I did property and casualty, would not cover independent contractors. They had to maintain their own insurance.
Yep, that's how it usually is in the IC world.
Mm-hmm. Yeah. Hopefully we answered that question fully. Any of you are welcome to unmute your phones and ask a question. If you do, we'll definitely call on you. But there's some really good information that you have on here, Victoria. And actually, it's kind of scared me on some of the things that I know that is going on out there.
Yes.
And the risk that people are putting themselves in just because they didn't necessarily know that you shouldn't be doing this.
Right.
Wow. So go ahead.
I was going to say, just if you want to look at Colorado Labor Department has a very good website that kind of breaks down how to make sure your contracts pass the test for independent contractor. I would completely encourage our Colorado constituents to go on there and check that out if they have any questions. It does a pretty good job.
Yeah, I'm sure the other states have some very good ones as well, because we do have people from multiple states on this call. Let me ask you the devil's advocate question. To me, it's the elephant in the room. When you're dealing with the IRS and the government, and it's like, oh yeah, well, only this is kind of protecting me, and it's filling in the gaps of where we are, but they really don't go after this stuff. But if a complaint is lodged against you, or if you are in an audited situation, that's when the red flags are really going to go up. Is that correct?
Absolutely. And as I said before, the federal standard, and at least the Colorado standard, is that person is presumed to be an employee unless you prove otherwise.
We had one person who was asked, will this information be posted somewhere for future reference? Yes, absolutely. We will be posting this to the You Define Wellness website. That's you as in YOU, definewellness.com. It will become part of the Healthy Living Library. And all you have to do is go to the section for wellness practitioners, and you will see it posted there. There will also be a link to it being on YouTube, unless, Victoria, you have a problem with me putting it out there.
I don't think so.
Okay, I think it's been fairly generic at this point in time. So yes, we are absolutely going to have it out there, because I think this is important information. And, if you're not in Colorado, Victoria's firm, Jackson Kelly, is in multiple states, and you can reach out to her. And if you could go back to your first slide, that would be awesome, so that we can have your contact information up. And there is her email address and her company website. Reach out to them. If you're not in one of the states listed, I'm going to wager your guess you may be able to direct them to someone. Yes. Because I know we do have people from California and from Wisconsin on this call right now. Okay. But if you are in Colorado, this is your go-to person. that you want to reach out to, and make sure that those contracts are protecting you and not hurting you. So I want to share a little bit of a warning out there. There is a practice that I have seen done repeatedly, and that is to borrow someone else's contract that you happen to find on the internet. You want to address that, Victoria?
Sure. I can tell you at least maybe 20% of my clients went into litigation because they relied on the contract that they pulled off the internet. So it's a big no-no. And you just need an attorney. You need somebody that can advise you on the legal ramifications of including certain provisions in your contract. And that's going to depend on whether or not you're hiring an employee versus an independent contractor, what industry you're in. There's all sorts of things you need to consider. And plenty of attorneys for first clients will do a free 15-minute consultation with you to see if they can help you. So if you're worried about costs and it's not something, of course, if you hire them, you're going to have to pay a retainer and help if they help you draft the contract. But even if you just have a couple one-off questions, it's better to do that than just to pull off a contract off the internet and rely on it. It's just, I would not advise it.
It also is indicative of professionalism. I did have somebody who was approaching me with a business idea that they wanted to introduce to my company. And she wanted me to sign a non-disclosure agreement so that I wouldn't just go do it by myself without cutting her into it. And she sent me the non-disclosure agreement. I took a look at it, and I'll tell you, my trick is to find a sentence within the document that is really unusual, particularly if it has a typographical error.
Yeah.
And I Googled that sentence, and she had borrowed it from a law firm in the United Kingdom.
Sure.
And so it wasn't even U.S. law. So, if when you guys are asked to sign a contract, you need to double check it. You need to get an attorney to take a look at it. If you're in the doing independent contractor agreements, it's far worth the price to have it drafted by an attorney who understands your business and what it is you're trying to accomplish.
Absolutely.
That's just my sales pitch for attorneys.
Well said.
Well, folks, we have plenty of time. Any other questions that you have that are weighing on you? Wow, you did a good job. Any last words that you want to add?
No, that's it. Just I agree, Denise. You just don't take chances. Even just spend 15 minutes with an attorney talking about, your business and what you're doing. Just don't do it alone, because the $600 or maybe $1,000 you spend at the get-go putting together the correct agreement is going to save you thousands and thousands of dollars down the road. You have to look at it that way. It's you're adding value by doing this right the first time. So just keep that in mind, and good luck.
Awesome. I just decided I would put this on here real quick. So if anybody wants to capture this real quick, I put our website is youdefinewellness.com. So youdefinewellness.com. So capture it real quick, and you can go over to our website and you will find it on there probably late today or early tomorrow morning. And with that being said, Victoria, thank you so much. You came highly recommended to me, and I see why. Thank you very much for doing this. Hopefully you'll have a lot of people contacting you and following up on those contracts. And we'd love to have you back again sometime.
Yeah, thank you for having me. I'd love to be back.
Yes, we will find a topic. We'll bring you back. And for those of you who are participating, thank you very much. For those of you who are watching this on our YouTube channel or our website or wherever you may have come across it, thank you for participating. And check out our Healthy Living Library. We have well over 100 videos on health and wellness topics to help you find your path to healthy living, as well as tips for health and wellness professionals to help you in your independent practice. So that being said, thank you all again, and we will see you on another video.